on a Bleeding Fools website, and they have a excellent website. Bleeding Fool and Bounding into Comics are sort of the more moderate media review sites. So let me start with the duty of care. In Heaven v. Pender, a 1883 case, judge declared the proposition is that whenever one person is by circumstances placed in such a position with regard to another that everyone of ordinary sense would at once recognize that if he did not use ordinary care and skill in his own conduct, how dare he use male pronouns? With regard to those circumstances, he would cause danger of injury to the person or property of another. A duty arises to use ordinary care and skill to avoid such danger. This is from Prosser and Schwartz, an old edition, but it's still relevant to this day. This is a noted passage, much quoted by courts and writers, notwithstanding the fact that 10 years later, in an 1893 case, the Lord was forced to retreat from his own words. As a general proposition applicable in the ordinary negligence case, where the defendant has taken some affirmative action, such as driving an automobile, it holds good. That is to say that whenever the automobile driver should reasonably foresee that his conduct will involve an unreasonable risk of harm to other drivers or to pedestrians, he is then under duty to them to exercise the care of a reasonable person as to what he does or does not do. There are, however, some defendants in some situations for which a duty does not arise. In other words, the defendant is under no legal obligation towards the plaintiff to act with the care of a reasonable person. Remember that phrase, the care of a reasonable person. It used to be called the reasonable man test, but that's horribly sexist, so we'll call it the reasonable person test. How would a reasonable person in similar circumstances behave? And is not liable even though his conduct falls short of that standard and the other is injured as a result. And this is true, although the danger is obvious and the risk entirely unreasonable, considered merely as a risk. We have already met two such situations. One is that of the common law rule that a gratuitous bailee is liable only for gross negligence in looking after the goods, earlier. The other is that of the statutes making the driver liable to gratuitous guests in his car only for aggravated misconduct. I assume by this they mean aggravated misconduct is greater than gross negligence? No, or is it lesser than gross negligence? I would say gross negligence is greater than negligence, and recklessness is greater than that, and then intentional acts are the greatest of all. Anyway, recall from earlier that duty is a relative concept. Negligence cannot be committed in the air. A person must build her case upon a duty owed to herself and not to another. That person must be within the class of persons who foreseeably will be injured as a result of the defendant's act. The principle may be stated, with few exceptions, that a person is guilty of the tort of negligence and therefore liable to pay a compensation for physical damages to the person or property of another caused by affirmative negligent conduct on his part. These are writings, I think, not cases. Accidents, Compensation in the Law, 1987, professor of English, then became a legal professor. The doubtful areas of the law, this book weighs a ton. The doubtful areas of the law are nearly all concerned with two principal questions. First, the extent of liability for damages of a kind other than physical injury, for instance, mental distress or pecuniary loss. Secondly, the extent of liability for omissions as opposed to affirmative conduct. Okay, that's a it goes on and it's very, very interesting. Somewhat dense reading. That's the duty of care, the concept of negligence, types of negligence, physical damages. So keep the duty of care concept in mind. Like I said, I was on Bleeding Fool, which is an excellent website. You should check it out. It's very well written. They have a bunch of very good writers, and it seems like they're seriously trying to make a go of it. Now, in retrospect, it seems like perhaps the title Bleeding Fool is kind of maybe a misstep, because it's I think originally it sounds like, well, are they just parodying Bleeding Cool, which is cancer? Yeah, they were maybe in the beginning, but they can stand on their own 2 feet. They are very, very good. They have very good writers, and they take an unbiased approach. Convicted sex offender front and center at all ages con panel. This is by David Lilly. Sometimes the furry community really screws the pooch. Wah, wah. Perhaps you're blessed enough to be ignorant of Growly. Suffice to say, he's earned multiple convictions for engaging in the sexual abuse of children. Okay, that's not funny. We launched a petition last year to ban convicted child and puppy abusers. I have a solution for child abusers. It involves a 115, a 180, or a 230 grain, high velocity, heavy metal. But I digress. To attending all ages furry conventions. Sweet Jesus. These people need Jesus. Our petition was more than simply ignored, but we'll get to that shortly, along with an important revision in light of recent events. Why is Growly relevant now? Oh, God. Because our policy would have prevented everything you're about to read. Sure, after his convictions, he served as staff with Redacted Con for a time. This kind of reminds me of Jeremy from The Quartering. He was calling out people who hurt children. So instead of banning the people who hurt children, the P to E to the D to the O's, they banned Jeremy from The Quartering. Because we live in clown world, and I'm taking crazy pills. He served as staff and has been drifting around the convention scene like a pungent Five Nights at Freddy's extra ever since. But it was only recently that convention staff saw fit to put him front and center, literally. Well, look who is down front and right in the center. I don't think I have the resolution on this $40 This Kindle literally costs $40, and it is amazing. Very, very good. Firstshoot.com. Okay. They need Jesus and they need therapy. So he's, I guess, down in center, but they're all wearing cosplay. So, and I'm not trying to attack the furry community. Have fun. Do whatever you want to do. Have fun as long as you're not hurting animals or children. That's fine, and I'm sure the majority of them aren't. But there are some in the furry community who need the gas chamber. This, just after Growly was scheduled and announced to be in charge of an all-ages... Oh, my God. We're in clown world. An all-ages interactive panel at a totally separate convention. Twitter was aflame, with attendees pointing this out to the official convention accounts, which ignored them or furnished legal excuses for inaction. And this is where we come in with duty of care and negligence. I believe... I didn't read the whole article. I just skimmed through it, and then I grabbed the torts book. I think I'm on the right area of law, but I could be wrong. I'm sure it will be corrected. Yet, when the target is truly dangerous, conventions can ban an individual from events in a heartbeat. Just ask 2 Griffin. Sarcasm here. One complaint over Twitter, and within a sharp 24 hours, the comedian had his 10-year anniversary invitation rescinded. The complaint alleged that 2 Griffin was a danger to children because he is a, get ready for this, transphobe. 2 Griffin is in a romantic relationship with an actual trans person who disagrees with that characterization, but that did not prevent the convention from acting with alacrity. Here's the weird thing. If you're in the LGBT community, or under the gay umbrella or penumbra or whatever it's called, all is well and good. You can almost do no wrong. But if you're in the queer community and you're right of center, all of a sudden you're a socialist from Germany in the 30s. The principles of the left are built on sand. Let's see what he says. The Portuguese guy says, a convicted sex offender is not only allowed at a con, but can also host an open-to-children event and stands front and center at their con pick. Not a single word from the furry fandom's favorite liquor lawyer. I guess that's Rakita. 2 Griffin is invited to a con. Now you get the booze cruising. Rakita law, speech is free, but lawyers aren't. Which sex offender are you talking about? Growly, a bit of an ongoing issue to say the least. At least they shut down 2 Griffin quickly and efficiently because they don't like his opinions. But a repeated convicted child predator, well, people have rights. You can't discriminate. Beautiful. Yes, we live in clown world. So if they can boost comedians, why not boot comedians? Why not kick out convicted criminals? Read on. Last year, I imagined our common sense solution would be embraced by convention staff. Well, you imagine wrong, buddy. I was dismayed to hear the opposite. Behind closed doors, it discussed our petition, chose to avoid addressing it openly, and instead formulated flimsy objections. They vary in absurdity, but the most depressing and durable excuse, liability. And here we come back to negligence and duty of care. Convention staff, I think, we may be in another area of law entirely, but law school was a very long time ago. Convention staff seem to think that banning convicted sex predators from all ages events would generate liability for these events. For months, this claim puzzled me. I thought it was the law to keep folks on the sex offender registry away from children. How could conventions have it so backwards? The two, Griffin Fiasco, finally uncovered details on their legal thinking. A furry lawyer, oh my dear, I'm not sure if he wants to be publicly credited. He went radio silent as soon as I had follow-up questions, responded to my inquiry with a few tweets, and explained a specific case law that has been propped up against our policy. I'm paraphrasing him here. If the policy were adopted, it could be argued to be an acknowledgement of duty of care and therefore increase the liability risk for conventions. In the Robutino case, creates a genuine issue of material fact in liability if an organization is aware of a potential danger and assumes steps to manage it, even if they otherwise would not have such liability. You know, that actually makes me think of the when you're in the middle of litigation and the defendant tries to alleviate a potentially dangerous condition in tort law, it can't be used against him. Something like if you're suing someone for negligence because of like a condition on your property or off your property, some kind of slippery sidewalk type of thing, or a bad railway or steps or something, and then the defendant tries to repair the slippery sidewalk, you can't use that against them because as a matter of public policy, it's good to have safe sidewalks as much as possible. And if you use it against them in litigation to perhaps move the burden, it would hurt the common good, I guess. Okay, so you see what they're saying here. They think if they acknowledge something, it will create liability. So the Robutino case, the specific rationale emerges from the darkness finally. I read up on the case. It surrounds a wild, drunken hotel party with hundreds of people that ended with guns blazing and third-degree murder charges. Okay, well, one thing you have to keep in mind is a convention center. There's different duties to different people who have different rights to be on different types of property, like invitees, lessees, privileged trespassers, like the gas man or the police or fire. If they have, well, fire is one thing, but police usually have like exigent circumstances and warrants and things to enter property. So there's different rights for different types of property, and a convention center is different from a hotel, though legally it might be very, very similar. Third-degree murder charges. I'm no lawyer, but some brilliant cartoonist, but just some brilliant cartoonists. Oh, but the basic furry claim here is, what a sentence that is. Banning convicted sex offenders from furry conventions increases the liability to conventions. Press F to doubt. Call me crazy, but my reading of the case seems to indicate the exact opposite of this claim. I haven't even read the case, and I'm tending to agree with you. Because as a lot of courts is common law, English common law, is some of its public policy concepts, and a lot of it makes a lot of sense. It's not super, super complicated. You want to alleviate public harm, risk to the public. So courts will interpret the law to cause the least amount of harm to the public. So this guy, I already forget his name, Lilly, I think he's correct. The case law seems to indicate furry conventions and their venues already possess a degree of liability, and that by failing to implement safeguards and a reasonable policy, their legal exposure is exacerbated. So if convention staff aren't compelled by morality to prevent convicted predators from mingling with children, or is interested in sidestepping Twitter outrage mobs, or inclined to prevent their dismal public image from becoming ever more tarnished, my God, what is worse than convicted predators from mingling with children? Yes, do everything you possibly can to stop those two groups from coming together. Every day, it just gets weirder and weirder. Do conventions have the liability issue backwards? I'm sure they do. Come along with me, perhaps by using the superpower of giving a crap for 10 minutes. We can find out together. This guy's pretty funny. Following are excerpts that seem pertinent from premise liability for third-party crime. Okay, I should have looked that up. Premise liability for third-party crime. An overview involving the Rabutino case by some more Italian guys. Let's fire up that armchair. The hotel owners knew or should have known about the dangers presented to the party guests, preventing convicted predators from attending all ages events, more or less liability for the event. A possessor of land who holds it open to the public for entry for his business purposes is subject to liability to members of the public while they are upon the land for such a purpose for physical harm caused by the accidental, negligent, or intentional harmful acts of third persons or animals. Okay, this is what I was trying to remember earlier. The degree of culpability relates to the degree of intent, I guess, is a way of looking at it. So accidental would be the least guilty, culpable, and then negligence just means you acted unreasonable. You didn't pass the reasonable man test. You didn't act like a reasonable person would under similar circumstances. And intentional harmful acts is, well, it's intent. It's having the mens rea and the actus rea coming together. Harmful acts of third persons or animals. Well, it's good you mention animals because you people are furries. And by failure of the possessor to exercise reasonable care to discover that such acts are being done or are likely to be done, or give a warning adequate to enable the visitors to avoid the harm or otherwise to protect them against it. Warning, slippery sidewalk. Post a little sign. Try to throw some sand on the ice or whatever they do. Preventing convicted predators from attending all ages events. Yes, we need to prevent convicted predators. Okay, dog. If the place or character of his business or his past experience is such that he should reasonably anticipate careless or criminal conduct on the part of third persons, either generally or at some particular time, he may be under a duty to take precautions against it. Okay, dog. Dogus interruptus. Preventing convicted predators from attending all ages events, more or less liability for that. The court supported the jury's findings that this was... Dogs have no manners. She just walked rudely right in front of the camera. I cannot believe the gall of this little dog. Adopt, don't shop. The best dogs are rescues. The court supported the jury's finding that this was knowledge sufficient to create a duty to take precautions. Ignorance of the potential for criminal activity in the area is not a reliable defense, as the standard includes whether the land possessor has reason to know. A possessor of land can be found to have a duty to investigate criminal activity in the area in connection with his premises. Preventing convicted predators from attending all ages events, more or less liability for the event. Yes, please keep them out. If the expert's recommendations are known and not implemented, and such information may support a plaintiff's claim of negligence. Preventing convicted predators, okay. One who undertakes gratuitously or for consideration, money, to render services to another which he should recognize as necessary for the protection of a third person or his things, is subject to liability to the third person for physical harm resulting from his failure to exercise reasonable care to protect his undertaking. If his failure to exercise reasonable care increases the risk of harm, he has undertaken to perform a duty owed to the third person, or the harm is suffered because of reliance of the other or the third person upon the undertaking. To illustrate this point, if a property management agreement contains a clause such as, property manager shall provide and maintain adequate and sufficient security at the premises, then the property manager can be deemed to have contractually assumed the duty of determining the reasonable necessity of security and its adequacy on behalf of the property owners, visitors to the center, and possibly the tenant businesses. Finally, the more liability argument emerges if you squint very hard. Venues which make security guarantees might be liable for neglecting to uphold these guarantees. But you'll note our policy proposal, and kudos to this guy for being a part of these this group that's trying to prevent people who hurt children from actually being around children. So you get my respect for that. Does not guarantee anyone security, well, you can't, or promise safety. It simply tells convicted child predators they're not welcome at the event. Although in the interest of being fair, well, the reason they probably don't want to the conventions probably don't want to bring up the issues because they don't want the publicity. They're hoping the convicted child predators will just go to their event and just leave their event and nothing will happen. So they're really behaving like sleazebags. Although in the interest of being fair to furry conventions and their whisperers, this appears to be the tiny misplaced grain of the core of their backwards fear. A fear which I solved at the end of this article, just as though it were valid. Heck, I'll solve it here. Alternatively, contract language in a property management or security services agreement could expressly state that this liability is not shifting to the property manager. Courts will enforce clear exculpatory clauses in contracts which may release or limit negligence claims against a party. Non-lawyer Dave provides you with the following clause for attendee agreements. Our policy and security measures should not be construed as constituting any guarantee of safety towards individuals in attendance. Attendee agrees to hold convention and venue harmless for any harm, abuse, harassment, or damage to one's persons that may be incurred by third parties or their attendees who are acting in contravention of convention policy. By appearing at the convention, the signee indicates that they understand the risk inherent. So this is a kind of an assumption of the risk, much like when you go to a ballpark and if you get hit by a baseball. I think, if I remember right, I'm just assuming the courts will say you've assumed the risk. I would have liked input from a lawyer on my above opinions. Well, lawyers cost money. And on the utility of the exculpatory clause that I pulled out of thin air. But you don't necessarily need a lawyer for a lot of this stuff. You can get a book on torts for like a used book very recently. It's probably like $5 or $10. The shipping is also $5 or $10, but it's very reasonable. And you can look some cases up online, but it's always easier to have like a torts outline book or a bar exam survival kit that goes through torts. Or whatever area of law you're interested in. Probably torts and criminal procedure are the two most common. I received no reply. It would seem furry attorneys spontaneously volunteer their legal opinions only when seeking to undermine our policy proposals, of course. When it comes to being constructive, we are left without the benefit of their vast legal wisdom. And you have to ask, like a real estate attorney probably doesn't remember that much torts if they went to law school 10 or 20 years ago, or in law school you learn a bunch of different topics, but then you go into practice. You don't practice every single topic. You're defense attorney or something. Then you're not remembering a whole lot of contract law, if any. There is no way to guarantee, regardless of the measures taken by a possessor of land, that a person will not be sued for negligence providing premise security. However, measures can be taken to defend against such a claim. A property owner or possessor of land must first be aware of the duty to take reasonable care to evaluate the likelihood of criminal activity at the premise and to appropriately police and secure the premises. Last time, preventing convicted predators from attending all ages events. More or less liability for the event. It almost seems like the convention centers are protecting child predators. And that's a very libelous statement to make, because it seems like if it's not true, and it's defamatory, because it's like the worst thing you could say is someone is a child predator. But what's worse than a child predator? Well, someone who allows the child predator and the child to come in contact, like the convention center. So I'm not sure the convention center's motivation, and I won't defame them yet. Believe it or not, I love furry conventions. That's a sentence I never thought I would say. I love the fursuits, the art, the performances, meeting friends and fans. This is why, all right, fair enough. People are having fun. That's cool. But you can't be inclusive to everyone. You cannot be inclusive to people who hurt children. You wouldn't, if someone came in the furry conventions and every time he or she came to the convention, she got drunk and beat up people, eventually you would ban her. You're not alcohol shaming them. I mean, this doesn't seem like rocket science to me. If someone's hurting people, if someone's getting drunk and beating people up, you would just say, hey, Jill, you're banned from this convention until you get some treatment. This is why I'm saying this, because there's a major problem growing in these events, which needs to be solved, and it seems everyone in charge is doing the opposite of solving. I understand that some furry community leadership prioritizes public image, media management, optics above all else. Perhaps they fear enacting this policy might look bad because it acknowledges the existence. Oh, damn it, dog. Dog comes in, walks in front of the camera, sits down for a few minutes, gets up, walks in front of the camera, walks out. Dog. Perhaps they fear, okay, I think we're at the crux of it here, 20 minutes in, and I realize absolutely nobody's watching 20 minutes of this. They fear enacting this policy might look bad because it acknowledges the existence of a problem. Bingo. Well, consider the optics of Growly, or the next Growly, or the one after that, serving as an indelible public face of your event. Consider the optics of preventable abuse scandals hitting the headlines. Consider the optics of tacitly, resultly, enabling some of the worst crimes a human can commit. Amen, brother. Convention staff, consider our proposal. It's already been adopted by 2 conventions. No problem. Consult competent legal counsel. I guarantee the convention has a lawyer associated with them. Probably a lawyer who deals with this type of thing. I believe doing the right thing will also radically reduce the liability to your event and to your venue. Attendees, I know everyone loves raging on Twitter and getting those likes, pure dopamine, but consider our policy or drafting one like it and engaging with the events you attend until they can meet a standard of decency that obviates the need for future tweet threads. Twitter. And old school furry gatekeepers. The only thing worse than bad press is bad press that you genuinely deserve. The article isn't antagonism, it's a warning klaxon. The control panel requires your intention. By David Lilly. Let's see. This is Bleeding Fool, and it is great. No responses, one comment. By Adder. This story is false. The person currently known as Growly is not a convicted sex offender or registered P to the E to the D to the O. There was another with the same alias 10 years back, and these snowflakes are getting confused and not validating their info. Interesting. These are the recent comments on the whole website. This is a very well put together website. I hope it does well. Bleeding Full. So anyway, like and comment and subscribe if you're not already subscribed, and definitely check out Bleeding Full and Bounding into Comics. They are. There's another article I saw here about this NPC culture taking over comics. It's kind of a little tiff between the people who are involved. Parties involved are Doug TenNapel, Pocket Jacks Comics, he's on YouTube, he's got a pretty funny site, Ethan Van Sciver, and the War Guys at War campaign, and these people are kind of sniping back and forth at each other. I'll make another video in a minute. Anyway, I hope you enjoyed this.